Hello, my name is Cynthia Elkins, and I'm a solo attorney in Woodland Hills, California. I practice in the area of employment law defense, representing employers in all aspects of their employment law concerns. What we're going to talk about today is independent contractors and do they really exist? This has been an incredibly hot topic for employment law and employers in the recent years due to the presumption in California that any worker is going to be deemed to be an employee. And when you classify somebody as an independent contractor as opposed to an employee, there are significant ramifications and consequences to that misclassification. And I'm going to go through some of those today. So the first thing that we're going to talk about is that there is a presumption in California that any worker is an employee. And this is based upon Labor Code Section 3357. And there's a seminal case from 1989, called S.G. Borello & Sons versus Department of Industrial Relations. This is a case that came out of the workers' compensation arena, but it has implications across the board for all analysis when it comes to an independent contractor versus an employee classification. And what this case talked about is that the contract of employment is a contract by which one who is called the employer engages another who is called the employee to do something for the benefit of the employer or third party. So that's the definition that we're going to start with. And from that, we make a determination whether that definition applies or whether we can go in a different direction and call somebody an independent contractor and pay them differently and have less control over the manner in which they're doing the work. My clients always want to classify employees as independent contractors. The reason for this is it's easier. You don't have the tax consequences, you don't have the control consequences, you don't have to keep track of their time, and it's just a lot easier if somebody's an independent contractor. But just because the worker wants it that way and the company wants it that way doesn't mean that that is going to be a controlling factor. And just because the parties agree to it, that does not come into effect at all when whether it's an administrative agency, a taxing authority, or a court is going to make a determination whether that classification is proper or not. The burden of proof to establish whether it's an employee relationship or an independent contractor relationship is going to fall upon the entity or the employer. They have the burden of establishing that if they set up that relationship as an independent contractor, it's going to be up to them to establish that before whatever agency or court they're in front of. And it's a heavy burden for them to meet because most of the factors are going to go against that analysis. The burden of proof is also talked about in Labor Code Section 3357 as well. Now, a lot of my clients also just go ahead and pay individuals by a 1099, and that is a de facto determination that they're an independent contractor. And the method in which you pay a worker for the services that they do is not a controlling factor. So just by paying them a flat sum, without taxes withheld, without any other state or federal withholdings, and giving them a gross amount is not going to be a controlling factor. Now again, many workers want to be paid by a 1099 because it gives them greater flexibility in terms of the deductions that they can take and the amount of taxes that they pay on those earnings. Just because the employee or the worker wants it paid by a 1099, again, is not going to be a significant controlling factor, and the employer is the one that ends up with the fines, taxes, and penalties and interest if there's a determination that that classification is wrong. So again, all of these burdens fall upon the employer, which is why it is so significant that the entity goes through this analysis with counsel or a human resource consultant to make that determination that whether the factors that are being looked at by these different state and federal agencies weigh in favor of an employee or weigh in favor of an independent contractor. I tell my clients to err on the side of caution, and I will most normally find in favor of an employee relationship because I feel that most of the agencies are going to rule that way, and it's just a safer practice. Also, signing a contract between the worker and the entity, calling it an independent contractor agreement, it is a factor that is considered, but it's very low on the list of factors to make a determination whether that's proper or not. So just because the parties have set out the terms, established that it's an independent contractor relationship, that the person's not an employee, they're not entitled to benefits, they're not entitled to anything that a traditional employee gets from an employer, that agreement is not controlling. It helps from the standpoint that it puts the parties on a level playing field so that the worker understands going into this relationship that they are an independent contractor, and it's less likely that they may file a claim when that relationship is severed. The fact that they're paid a commission also does not control. Wages, commissions, however you pay the person, that is not a controlling factor. The person performs assignments for more than one entity. That is also not a controlling factor. These are things that are taken into consideration, but not one of them has greater weight than the other. The one consideration that is given the greatest amount of weight by the different agencies is called the right to control test. So that is who has the right to control the methods, the means, the manner in which the work is being performed. So if you as the entity tells the worker, I need you here every day at 8 o'clock, I need the work performed in this manner, here's the computer program that you're going to use, this is the criteria that I want you to follow, you are controlling the manner and means in which that job is being performed. The more control you exert, the more there's going to be a finding that that person is an employee, not an independent contractor. To the converse, if you give somebody an assignment, they work at their home or off-site somewhere, they use their own computer, they use their own computer programs, they can work at 2 o'clock in the morning. They don't need to be anywhere at a specific time. You've given up control, and all that you're really worried about is that final product. What are they turning into you? So the more control that you have, the more it's going to be an employee. The less control that you exert, the more there could be a finding of an independent contractor. Now, the IRS has established many years ago a 20-factor test. That test is still sort of in effect, but they have modified it and broken it down into different ways. And the Employment Development Department has their own test. The Workers' Compensation Board has their own test. The Division of Labor Standards Enforcement has their own test. Each state and federal agency has their own test that they look at in terms of what factors to consider in making a determination under their guidelines. Most of them stem from this 20-factor test by the IRS, but they look at them differently. So the Employment Development Department, they look at three things primarily. Do you instruct or supervise the person while the person is working? Can the worker quit or be terminated at any time? Is the work being performed part of your regular business? If you answer yes to those questions, then there's going to be a strong indication that that person is an employee, not an independent contractor. And the problem that I see with most of my clients is that last factor. Is the work being performed part of the business? The more that it's part of your regular course of business, the more the person is going to be considered to be an employee. If it's something separate, like in my firm, you know, if I were to hire somebody to do my web page or rebrand my logo or create a marketing plan for me, that's not an integral part of me being an attorney. That's subsidiary to my practice of law. That person could be an independent contractor. If I hired somebody to write my briefs for me and they did it on a regular basis, that's an integral part of my business. They're likely going to be considered to be an employee. Now, one of the things that is helpful in finding somebody as an independent contractor is that they have established their own business. They do this work for other people, they've created a business name, and if you're compensating them, then you're paying that entity. So if it's Joe's printing business, I'm writing check to Joe's printing business, not Joe Smith. Those are the type of things that are going to lend itself to be more of an independent contractor than an employee relationship. The other thing that's critical is, does the worker have a significant investment in their profitability? So if I hire somebody and I pay them a flat fee to do something, if it takes them 10 hours to do it, they've made less money. I'm still out of pocket the same amount, but they've made less money because it takes them 10 hours to do it. If they do the same project in 2 hours, then they've made more money, so they have the right, or the ability rather, to control their profit and loss in the way that they do their work. The Labor Commissioner also uses basically the same test, and they are also going to presume that the worker is an employee. Now, if somebody is considered to be misclassified, so you've classified them as an independent contractor, and through one of these agencies there's a determination that they are in fact an employee, there is a labor code section that provides that the willful misclassification of a worker as an employee can result in penalties. There's also tax consequences. These are substantial. The misclassification can also result in overtime claims, meal and rest break claims, all sorts of other wage and hour claims, because the person is being paid a lump sum, not for the actual time that is being spent. And under the labor code, The willful misclassification starts at a $5,000 fine, goes up to $15,000 for the first violation, and after that the fines increase to $10,000 to $25,000 if there's a pattern or practice of repeat violations. These are substantial penalties and fines for the willful misclassification. Thank you very much.